Hello viewers and welcome back to Dukascopy TV. I have Damien Neven of the Graduate Institute of Geneva in the studio once more. Today we're going to be looking at that recent Intel judgment. Damien, thank you very much for popping back in with us.
Thank you very much for the invitation.
No problem at all. Now, for those of us not perhaps up to date on this story, can you give us a little bit of a background into this judgment?
Right, so this is a judgment upon appeal of a decision that the Commission took in 2009. And in 2009, the Commission took an infringement decision, so essentially found that Intel had violated Article 102 of the treaty, which is the article that deals with the abuse of dominant positions. And the Commission found in that decision that first Intel was dominant, but that was not really a big issue because, Intel has 80% more or less of the market for CPU, or at least one particular type of CPU which is compatible with the x86 architecture which you find in most PCs. And more importantly, that Intel had abused of its dominant position in two ways. First, by granting rebates that were considered to be exclusivity rebates. So these are rebates that Intel was giving to the main OEMs, to HP, Dell, NEC and so forth, such that these buyers would get a reduction on the price of the CPU if they would commit to buy only from Intel and not buy from what was at the time Intel's main competitor, AMD. And the second infringement that the Commission found is with respect to so-called naked restrictions. And naked restrictions are also a form of abuse, such that, again, the buyers would get a remuneration from Intel in exchange for adopting a particular marketing policy. And for instance, there was an example in the decision about a payment that was received by one of the OEM in exchange for delaying the entry of a product that would use the AEM CPU. So that's the background, and Intel appealed that decision to the General Court, and the General Court rendered judgment 10 days ago, and importantly has completely affirmed the Commission decision. So basically it has not changed at all the content of the decision, and it has affirmed the 1 billion fine.
Now, just to touch on that fine a little bit, in your view, is this disproportionate really, particularly if we consider that the EC did actually levy this fine 5 years ago? It still seems a phenomenal amount even now, let alone sort of 5 years ago, which would have been, sort of around crisis era really.
Of course, they paid 5 years ago. So this what has been done now is that the Commission, the Court has just affirmed this fine. But I don't think that the fine is really the most important aspect of that decision or that judgment, because 1 billion relative to the business of Intel during the infringement period, which is a 5 years infringement period, is actually not all that significant. And if you think that these retroactive rebates or these exclusivity rebates that Intel was giving to the OEM has allowed them to extend their monopoly power, has allowed them to be more profitable during that period, probably the 1 billion is only a fraction, if indeed all of this is warranted, is only a fraction of the additional profits that they have generated.
If we consider from the European Commission's perspective, how important is this upholding of this lawsuit in terms of the EC's pursuit of this kind of antitrust behaviour?
Yeah, this is a very significant judgment, because the appropriate antitrust policy towards rebates and exclusivity rebates in particular has been subject to a significant debate in the last few years, and there is currently a divide across the Atlantic, in the sense that the attitude of the US authorities, the Department of Justice and the Federal Trade Commission towards these exclusivity rebates is now very different from what it is in Europe, with a much more lenient approach towards that sort of rebates. Now, so there has been a debate in Europe, and in particular there has been a debate within the European Commission, and the European Commission has tried to move away from a very strict per se prohibition of these exclusivity rebates and try to implement a policy which is potentially more, I wouldn't say more lenient, but it's, I mean, certainly trying to make a distinction between the exclusivity rebates that are really anti-competitive, really foreclosing the competitors, and those that may not be anti-competitive, that may actually be good for competition. Because at the end of the day, this is a rebate. I mean, a rebate is a reduction in price, and that's something that is potentially good for the OEMs and for the final consumer. So it is significant because this debate has taken place, and it now looks like the court is affirming and in some ways going beyond even its previous case law, really affirming that these exclusivity rebates are unlawful.
What is the next step then for Intel? And also, how would you respond to comments that with AMD's market share kind of wilted really, that Intel's action, albeit unlawful, could still have been worthwhile?
I mean, it's entirely possible that it would have been worthwhile. They still got $1 billion fine, which clearly has taken away some of the profit that they may have made. No, I think that the consequences are, of course, for Intel in terms of the rebates that they can grant today towards the OEM. But I think that the consequences are more significant for all companies that are in dominant position or in a quasi-dominant position. And I think that these dominant companies want to be much more careful now after this judgment that they may have been before about the type of rebate that they can grant. And I think that it's probably safe to say that they should move away from exclusivity rebates and maybe, I mean, use different types of rebates that may be looked upon as being sort of less anti-competitive by the Commission and the Court. This may include simply volume discounts or include retroactive rebates, but then retroactive rebates that are subject or that are triggered by meeting of a particular threshold in terms of sales rather than being contingent on exclusivity.
Damien, thank you so much for coming in and sharing your thoughts with us. Pleasure, thank you. The Dukascopy TV team continues to bring you insight into some of the big market headlines. For now, though, it's goodbye.